In this session, we're going to talk about the period of time between when the divorce is filed and when the divorce is settled. And in different states, that could be a different period of time, but it can be many months or it could be a year or more. So in most states, that's sort of called the temporary time period. And during that time period, there needs to be some sort of arrangement set up so that everybody knows who's living in the house and where are the children living, who's paying the bills, what's going on with the savings accounts, sort of what's your life going to look like for this time period. And there's different ways that you can go about coming up with a plan for that period of time. One way is that you don't even need a plan because, one of you moves out and the other one says, I'll take the kids on Mondays and Tuesdays, and someone else says, I'll take them on Wednesdays and Thursdays, and you work it out and it's no big deal. In other situations, you want something a little bit more formal. And those formal arrangements can be either agreed upon between you and your soon-to-be ex so that you could kind of write it down and then you could follow a written agreement. But the best way to make sure that things are stable during that temporary time period is if you enter into a court order. And that can be either an agreed order or it can be an order where you actually go to court and a judge or a court commissioner makes a decision for you. So let's just kind of start back with the sort of the least aggressive, and that would be called an agreed temporary order. Sometimes it's called an interim order. There's all different terms in different states, but the basics for issue spotting purposes, what you want to think about is that there's some way of coming up with an agreement that's enforceable because it's entered with the court that explains how things are going to happen for this period of time. So let's assume that you and your soon-to-be ex agree he's going to move out of the house and you're going to stay in the house and you're going to pay the mortgage, he's going to pay the utilities, and here's what's going to happen with the kids. You guys can totally agree on that, and in most jurisdictions you can go ahead and write up a court order that usually has to follow very certain court procedures, and they have to be written in a certain way and follow the rules in your particular jurisdiction. But once you figure out what those are, you can go ahead and write those up and sign off on them, enter those with the court, and then you can follow that agreement over the period of time until you either settle your case, which is likely if you've reached an agreed order, or maybe you're going to go to trial. So let's say that you can't agree. Let's say that both of you want to stay in the family home, and both of you say that you're the primary parent or you're the parent who's most involved with the children. And let's say you feel like maybe you need some financial assistance and your soon-to-be ex thinks you don't need any financial assistance because you could go get a job real quickly and make a lot of money, or more commonly, you're working at a job that's below your credentials and 15 minutes from now you can go get a better job and you can make more money. So let's, you're in some sort of a disagreement about that. So you're going to have to go to court. And you're going to go to court and you're going to present evidence in a temporary hearing. And in some states, those hearings are heard in front of what's called a court commissioner, which is sort of not exactly a full judge, but it's a court official, wears a black robe, and it's in a courtroom and everything in most places. And you're going to make your argument there that explains why you think you should stay in the house or what should be the parenting arrangement between you and the kid's dad. So how do you get that information before the court? Well, if you have a lawyer, your lawyer will take care of this for you. If you have a lawyer, your lawyer will take care of this for you. But it's really important that you understand what your lawyer is doing because you want to be a good, active consumer and you want to be involved in the process. So the way that we get a court, either a judge or a commissioner, to make a ruling is we have to file a motion. And a motion is basically a legal term for making a request for the court to make a decision on our behalf. So this can't happen until the court has jurisdiction over you, and we've talked about that in the divorce process. Once the case is filed, then the court has jurisdiction over you and your family, and the court can make decisions about you in financial and in parenting and who's going to live where. So we filed for the divorce, the court now has jurisdiction, and then one of you is going to make a motion to the commissioner or the judge that says, here's what I would like to have happen. Well, obviously the court official doesn't know anything about you, doesn't know, who's been the one taking care of the kids and who's been living where and what's been going on in your family. So you're going to have to bring evidence before the court. And in different places, there's different ways of presenting evidence, but basically, usually there needs to be some sort of an affidavit that's signed under penalty of perjury by you and your witnesses. And then there's also going to be kind of like financial evidence. It's going to be bank statements and employment records and things like that. So the court wants to have a really good picture of exactly what's going on in your situation, and that's your responsibility to provide that to the court. So the three things that usually happen in the temporary orders would be there'd be a parenting arrangement that would be ordered, and then there's going to be some sort of a situation about who's going to be living where, and there's going to be a financial arrangement. So let's just take those in order. The first thing is obviously parenting, because that's the most important. Every state has some sort of statute or some sort of law that talks about how the decision is made about who's going to be responsible for what part of parenting. And generally speaking, at a temporary orders hearing, the commissioner or the judge is going to follow the law in your jurisdiction. So you want to be familiar with what that statute says. And as we talked in the child custody section, generally speaking, there's things that the court would like to sort of keep the status quo, which kind of means that they don't want a big upheaval in your children's lives. So if you're the one who generally gets them up in the morning and gets them to school and takes care of them and makes doctor's appointments and handles all the social engagements, then the court might say the kids are going to spend more time with you. But at the same time, the court also knows that those kids need their dad, because guess what? The children are not divorcing their dad. Parents are getting a divorce, but the kids need to have a lot of time with both parents. So in some states, they sort of have a primary parent and they talk about joint custody and sole custody. You have to find out what it is in your state, but the point is that at this temporary orders hearing or interim order hearing, you're going to present evidence that follows that statute. And the way evidence is usually provided, like I said, would be some sort of a written statement. In most states, you can't testify at a temporary hearing, but some places you can. So what do you want to say? Well, you want to write a declaration or an affidavit that follows the statute. So whatever your state statute or your state requirements are, you want to provide your statement about how your situation meets the criteria that's in that statute. At the same time, the other side is going to be writing, and you're going to say, well, I'm the one who gets up and makes breakfast and takes care of the kids and gets them to school and does their homework and reads them a story, and then your husband could say the exact same thing, and a judge isn't really going to know. So now you're going to be looking for other evidence. And what kind of evidence are you looking for? Well, how about daycare records? Who drops the kids off at daycare in the morning? Most places you have to sign in. Who picks them up? You can prove that by the sign-in and sign-out sheets. So the court's going to be looking for evidence, and they like to have evidence that's sort of objective. They don't necessarily believe your mom or your sister or his mom or his sister about what's going on in your family. They're really looking for, let's try to figure out exactly what's going on here. And so for this temporary time period, we would like to maintain the status quo so that the kids are comfortable, and of course their world has been completely rocked, but you're trying to keep it a little bit stable for them. So the court will come up with a plan or a schedule, and it depends where you live, what is the common schedule in your particular area, and if you talk to your lawyer or you probably go online and look around, you're going to find some sort of common schedules. But it's usually either with mom during the week and midweek visit with dad and weekends or every other, something like that. But anyway, that's going to happen for the temporary time period, and you're going to have evidence that you're going to present to the court about your family. So then the next question is, how are you going to make it financially during this time period? Because it's going to be many months probably before you're able to settle your divorce or before you go to trial. It might even be a year. So how are you going to pay the bills, and who's going to pay the mortgage or the rent? How about the car payments and the utilities? That's another thing that you're going to present to the court. And the court's not going to just generally believe you that says, I don't have enough money to pay the bills. Court probably wants to see copies of everything. So remember we talked about the divorganizer, that divorce planner that we have available to you. That's where this is going to come in incredibly handy. Because in most places, they're going to require you to present copies like of your bank records. Because if you say, well, I can't afford to pay the mortgage, but you got $30,000 sitting in the bank, the court's going to look at that and say, well, why can't you use that money to pay the mortgage or something like that? So they're going to look to they're going to usually want copies of everybody's pay stubs. They're going to want copies of bank statements, credit card statements. They probably want a mortgage statement, maybe your lease on your apartment if you're leasing, and copies of those little coupons that when you make a car payment, those types of things. So you're basically explaining to the court exactly who pays what bills and who has how much money. And that's when you want to come in with your budget. And your budget is going to have to be outlined, and there's the budget in the divorganizer, and most states have a sort of a required format for that. But you're going to say, this is my income, this is my mortgage, this is my utilities, this is how much we spend on food. Oh, and by the way, the kids are in soccer, and here's the soccer activity fees, and one of the other kids takes piano lessons. You want to put all of those things in there, and you have to have backup for that. You want to have copies of the invoices and the bills, and it wants to be very, very organized. So the court can look at that and say, okay, I see, here's your budget. Maybe your budget is $3,242 a month, and your income's only $2,057 a month. It's easy for a court at that point to say, wow, you need some extra money, and then they're going to look to your ex, or husband at that point, and see what his income is. And then he's going to say, well, wait, I have to rent an apartment, and I have all my own expenses, so he'll also have a budget. And the court's going to weigh those two budgets, and then there's the issue of child support. So they're going to weigh the budgets, look at your incomes, determine how much child support one or the other of you is going to get, and then they might make a provision for temporary spousal maintenance, which is also called alimony. And that's going to get you over for the time period between when you file for the divorce and go for this temporary orders hearing, all the way up until the case is settled. So it's really important that you present full evidence, because it's very difficult to change temporary orders in most places. Courts don't want people coming back every week or two and say, oh, I forgot, the kids are in therapy and I forgot to submit that bill, and so can we please increase my child support or my temporary alimony? Because the courts don't really want people coming back in like a revolving door. So it's super important that you bring all of the evidence that you can gather together to that temporary orders hearing, and be sure that it's in the format that's required by your court. If you have a lawyer, your lawyer's going to know that format. But if you decide not to have a lawyer, in most places they're going to hold you to the same standard as a lawyer. And that means you're going to have to read the court rules. You're going to have to know what the pleadings look like that you have to submit. So whenever you're asking the court for something, and you're filing a motion, whenever you submit paperwork to the court, it's usually called pleadings. And you might have seen copies as that paper with the line down the side and the numbers on all of the lines. And then there's a caption on that that sort of says your divorce caption, like, Sally Jones versus Bill Jones or something like that. So the court's going to want to have everything presented in the exact right format. And if you don't do it right, sometimes they could just say, you know what, we're not going to have your hearing today. You're not going to be able to present this information to the court because it wasn't done properly. So if you have a lawyer, your lawyer should certainly know how to do that. But if you don't have a lawyer, pay attention to the court rules. Oftentimes there are page limits for this. You can't generally, in most places, come in with 100 pages worth of, you've got a affidavit from every parent in your child's class and every kid on the soccer team's parents, and everybody says, that you're the mother of the year. Well, it's probably true, but the court's going to have some sort of a page limit, so you have to be careful and decide which people you want to have sort of testifying on your behalf in that hearing.